Alex here with part 13 of the My Docket series on child custody and visitation. As with the previous videos on this series, I'm going to direct everyone to part 0 if they haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of this series. Two things that I will glaze over are, number one, I am not in the middle of this right now. My case is completely and totally closed. It's over. My ex's parental rights were terminated. It cannot be reopened. Number two, the purpose of the series in a nutshell is to provide my viewers with one big gigantic example of my high conflict child custody dispute from beginning to end in chronological order. Part 11 was where we left off with my ex's attorney's filing of a motion to set holiday visitation. In this video, we're going to take a look at my response to that motion. I'm not really going to cover any of the sort of details on the appropriateness of my ex's filing in the protective order action in this video because I already covered that in part 11, so definitely take a look at that video if you haven't seen it yet, because you're not going to know some of what I'm referring to or referencing to when I actually cover my response to that motion. And I do not imagine that this is going to be a very long video. I'm just going over one paper that I filed. So all that being said, let's take a look and see what I have filed. So here we have the response to motion that I filed. This is a self-help form, so at this point I still haven't prepared or learned how to prepare custom papers and pleadings, but eventually that is going to happen. I know I've talked about this in several of my previous videos, but I really like to drill it home. And in fact, if you want to know the details as to why it's important to learn how to prepare custom papers and pleadings in a high conflict case, I stress that, then definitely take a look at part 1 of the My Docket series, because that's where I go in depth. Scrolling down, you'll see that I refer specifically to the motion I'm responding to. In this case, it's the motion to set holiday visitation. I also refer specifically to who filed it and the date that it was filed. You're typically going to see this in the first paragraph of any self-help form, and when it comes to custom papers and pleadings, you'll typically see it in the first paragraph there as well, especially if it was prepared by an attorney. If it wasn't prepared by an attorney, there's a chance that the person representing themselves doesn't know the importance of doing this, but it's kind of self-explanatory. If you're going to respond to some kind of document, some kind of filing, you're going to want to let the court know specifically what it is you're responding to, and it helps the court to both know the name of whatever it is that was filed and also the date that it was filed on. The first thing I do here when I respond to the motion that my ex filed is I refute the notion that I missed one of the days of visitation based on me going to work. Why did I do that? Because it wasn't true. What I think my ex is doing here is trying to deceive the court in a way that gives her an escape hatch or an easy out or a back out. I don't know what people refer to this as, but it's basically a lie that allows the person an out if they're confronted with assertions that they're falsely accusing somebody of something or lying. And what she's doing here is saying that it wasn't available for Friday visits, but in actuality, she's referring to the first 2 weeks of supervised visits where there was no set schedule. There was a set schedule that included Friday visitation after those 2 weeks, and those visits were unsupervised, and I didn't miss a single Friday of those visits. But the first 2 weeks, that was a supervised visitation schedule that was to occur whenever the third-party supervisor was available to allow me to exercise visits. And so I communicated with that third party, and we set up a few days here and there when he was available to supervise the visit. So it's basically a way for her to assert that I'm not exercising my custodial time, yet if she's confronted by the court and me, she can say, oh, well, I didn't know, I got confused. I thought that the visitation schedule during the unsupervised visits applied to those first 2 weeks as well. This is something that she does all the time, and it's kind of, in my opinion, It's like she's sort of gaming the system, hoping that I'll overlook something and that I won't refute it, and then the court will think that, you know, I'm doing something that I'm not doing. And she tries it nonstop throughout the 8 years of the high conflict child custody litigation. And anytime she's called out on it, she just says, oh, I was confused. Oh, I didn't know. Basically, she plays stupid. But if you want to know specifically what I'm referring to, watch part 11 of the My Docket series, because that's where I go over the motion that she filed, and that's the motion that contains the assertion that I didn't exercise my Friday visits. And you can also watch part 9, I believe, of the My Docket series, which goes into the final written order that sets forth my visitation schedule. You can also actually take a look at part 8 of the My Docket series, because that has the hearing video where the domestic master pronounces from the bench what my visitation schedule is to be. So there's plenty of videos that reference what I'm talking about, and you can definitely go back and take a look at those videos if you want to get the full picture as to what I mean by the confusion, or at least the confusion that she's trying to claim. And she does eventually claim being confused later on when confronted by it. I do remember that this comes up later on in court. She tells the judge I wasn't exercising all of my visitation, and well, when she gets called out on this, she just claims she was confused or that she didn't know. Moving on to, oh, by the way, you will see that when I actually get to that point in the process. When we get to that hearing, I'll have the video posted and you'll be able to watch it. The next paragraph, I agreed to allow her to take the child to San Francisco from November 10 to 15. The reason that I agreed is because I didn't have anything special going on that particular span of days. And my ex's attorney offers to let me have some makeup time, and that sounds just fine to me. So since I wasn't doing anything that was a big deal on those days, and since I was going to get makeup time, okay, I had no problem with that at all, so I just straight agree with it and stipulate to the details in my ex's motion. Moving on to the next section, I actually object and oppose my ex getting December 22 to 26. And the reason why is because I did have plans on, within that specific span of time, I wanted to take my son to see family for Christmas. And the reason why is because I hadn't seen him in 8 months. For those of you who haven't seen part 1 of the My Docket series, I talk about the gigantic span of time in which my ex refused to allow contact with my son. And so at this point, I'm finally starting to get some visitation, and I want to, you know, spend Christmas with him because I haven't seen him hardly at all that year. So the way that I object to it is, number one, I claim that I haven't seen him very often throughout that, you know, the last 8 months, which is true. But number two is actually the point that hits home, and that's the point that the judge, or in this case, domestic master, will make her ruling on. Number two is that this motion is not appropriately before this court in the first place. We have a child custody action that is open. We have a case management conference that is coming up, and that is in front of a duly elected presiding district judge of the family division. So I oppose on a second point, stating that this domestic master should not be exercising her authority or her jurisdiction over this issue because it's not a protection order issue. The job of that domestic master is to enter an extended order of protection or dissolve an order of protection. It is not to get all up into these child custody issues. So I object on that point, and I request that this domestic master deny my ex's motion, or at least a portion of it that requests that December visitation, and direct my ex and her attorney to bring this issue to the attention of the district judge. And later on, you will see the order that the domestic master enters on this motion and opposition, and you will find that the domestic master agrees with me on that point. It looks like I am saying, oh, right, for Black Friday. Okay, it's kind of hard to read my chicken scratch. So I'm also telling the court that since I have to spend a lot of time at work because of Black Friday, that's another basis for agreeing to allow my ex to have that November visitation. And then the next sentence is the same thing, willing to allow her to have the Thanksgiving holiday. This portion here where I'm saying that I do not request a hearing on this matter, I would rather direct my viewers to part 12 of the My Docket series, because I explain in detail What is behind that little blank right there where you can tell the court you do or don't request a hearing on this matter? In a nutshell, I have recognized that my strength is writing, at least in comparison to oral arguments, which is just something that any non-attorney is going to be weaker at because attorneys are in court all the time and so they can practice all the time. Whereas us non-attorneys, the only place we can even get close to practicing is writing, because you can hit the backspace key, do multiple drafts, and you might have a document prepared and then a few days later decide, oh, I thought of something that can add in there. You can't really do anything like that in a hearing. You're on the spot. And so that's kind of my perspective as to why I would frequently tell the court I did not request a hearing. But there's a whole lot more to it than that. And again, I would direct my viewers to part 12 of the My Docket series, because when I go over that little portion of the video, I go a whole lot more into detail as to what a hearing entails, and also the fact that there are different types of hearings, which is almost more important to cover. In fact, I'll take this opportunity to direct my viewers to the videos Hearings and Motions. Those are two separate videos, and I go into detail in both of those different videos the whole point as to when you want a hearing, and also what the different types of hearings are and what the purpose is behind them. And since I didn't ask for a hearing, this next portion I could just put non-applicable, because that's just where you state why you feel one is necessary. This is the affidavit in support of the response. I've mentioned this before on many videos. It is basically the affidavit that binds you under penalty of perjury to all the things that you've alleged in the particular paper that you're signing. So without this, you aren't swearing under penalty of perjury that anything in the document is true. It seems kind of silly to a lot of people because it's like a court paper, so people are going to know that they shouldn't be lying in a court paper. But this is a technical requirement. It's in the court rules, both in the 8th Judicial District Court rules and in the 2nd Judicial District Court rules, which is where I mostly represented myself. And so if you don't have an affidavit in support of your motion, it could be a basis for the court to deny the motion. So it's a requirement, and as you can see, it's in the self-help form. Here we have the affirmation. I've talked about this multiple times as well. This is a piece of paper that just tells the clerk of the court that you have reviewed it and that there is no social security number in the document. Here we have the family court motion opposition notice, also a document I've gone over multiple times. It is a document that contains a series of checkboxes, and you go in order from top to bottom, marking the boxes according to the questionnaire. And depending on your responses, you will come to a determination as to whether or not you have to pay a $25 filing fee when you file this document. In this case, I checked the first box, no, and according to the instructions that I didn't have to proceed any further, and so I didn't have to pay a filing fee when I filed this. Here is a second affirmation. This is totally unnecessary. I explained in the previous video, part 12, why I think I did this, and in a nutshell, in the very beginning phases of my case, I was getting turned away from the filing office a lot, and I was getting turned away because I was missing certain papers, I wasn't doing the right thing in certain forms, and the clerk would have to send me away and tell me, fix this, this, and this, and come back. One of the things that I got sent away with on multiple occasions was the affirmation. I didn't have the affirmation included in my documents, and so in this case, I probably was paranoid that I needed an affirmation for the specific page of the motion opposition notice that I just went over, which is, I didn't need that at all. I could have just had one of these attached and that would have been good enough. But anyway, let's move on. Going straight into the aftermath, neither myself nor my ex incurred any costs. She didn't file any of these documents. I did file the document, however, it didn't require the posting of a filing fee. I didn't even serve this document, apparently. I don't see a certificate of service on the document with regards to this document. There's a possibility that I did serve it and I just didn't know that I had to file a separate proof of service or affidavit of service. So maybe I did serve it, but what it's going to come down to is if I did, nobody's going to know that I did. At least the court isn't going to know. My ex didn't raise any kind of objection, and honestly, attorneys, at least as far as I know, are signed up for an automated system. It's an electronic system that automatically notices them when things are filed. So she probably got a notification electronically that I'd filed it and just didn't even care that I didn't serve her, if I didn't even serve her. So because of all that, I didn't have any service of process fees. I'm assuming that I served it myself or I didn't serve it at all. And so my costs were also $0. Attorney fees, I didn't have an attorney, so I incurred $0 in attorney fees. My ex had an attorney that reviewed this and probably spent, it's tough. I'm on the fence between 15 and 30 minutes. I'm going to lean towards 30 minutes because my opposition, it was pretty substantive. It was kind of a joke. It didn't contain any points and authorities, but the points that I made, they're good points. And like I mentioned earlier, it did resonate with the domestic master. She actually agreed with the points that I raised. So let's say that the attorney spent 30 minutes reviewing it, and at the rate of $250 an hour, which is what we've been using throughout the series, let's count that towards my ex's attorney fees. Let's count $125 towards the attorney fees that she probably ended up having to spend on having her attorney review this response to motion. So, as with my previous videos, definitely post something down in the comments below if you have any questions. You'll be able to download the document if you look down in the description. You'll see a link to it. And I'll see you guys next time.